When life gets complicated and probate feels overwhelming, there's a clear path forward. Welcome to Clear Probate, where we cut through the confusion and guide you every step of the way.
Welcome back to Clear Probate, where we make Florida probate and estate planning easy to understand. If you've been named as an executor, or as Florida calls it, a personal representative, one of your most important duties is filing the notice to creditors. This isn't just a piece of paperwork. It's a legal requirement that protects the estate and ensures debts are handled properly. Missing deadlines or filing incorrectly can lead to serious consequences, from creditor lawsuits to delays in closing the estate. In today's video, we'll break down everything you need to know: what a notice to creditors is, why it's required under Florida probate law, the deadlines you must meet, a step-by-step guide to filing, how creditors respond, and practical tips to keep the process smooth. By the end, you'll know exactly how to handle this step with confidence. Let's start simple. When someone passes away in Florida, their estate may still owe money. That could include credit card balances, personal loans, medical bills, mortgages, or even taxes. The notice to creditors is the legal way to inform anyone who might be owed money that probate has begun, and that they must file a claim by a certain deadline. The notice is published in a local newspaper and also sent directly to any known or reasonably ascertainable creditors. It's a way of drawing a line in the sand. Creditors have a limited window to make their claims, and if they don't, those claims are usually barred forever. Think of it as a public announcement. The probate process has started. If you think you're owed money, now is the time to speak up. The notice serves two main purposes. First, it ensures fairness. Every creditor, whether a large institution or a small business, has the opportunity to come forward. Second, it provides closure. By setting a clear deadline, it prevents creditors from showing up years later demanding payment. Without a notice to creditors, the estate could remain vulnerable indefinitely. Florida law takes this step seriously because it balances the rights of creditors with the rights of heirs and beneficiaries. It protects everyone involved by creating transparency and structure. Now, let's talk about deadlines, because in probate, timing is everything. Under Florida statutes, the notice to creditors must be filed and published within 30 days of the personal representative's appointment. Once the notice is published, creditors have 3 months to file their claims. For creditors who are known or reasonably ascertainable, the personal representative must send them a direct copy of the notice. Those creditors then have the later of 30 days from receipt of the notice or 3 months from the first publication date to file their claims. If they miss the deadline, their claim is generally barred, with very few exceptions. Example: suppose you're appointed as personal representative on January 1st. You must publish the notice to creditors by January 31st. If the notice is published on January 15th, creditors have until April 15th to file claims. A hospital bill received by mail on February 10th would give that hospital until March 12th or April 15th, whichever is later, to file. Let's walk through the steps of filing a notice to creditors in Florida. Step 1. Appointment of personal representative. You can't file the notice until you're officially appointed by the probate court. Once you receive your letters of administration, the clock starts ticking. Step 2. Drafting the notice. The notice must include the name of the deceased, the probate case number, the court where the case is pending, the name and address of the personal representative, the name and address of the personal representative's attorney, a clear statement of the deadline for creditor claims. Step 3. Publication in a newspaper. The notice must be published once a week for 2 consecutive weeks in a newspaper that circulates in the county where the probate is filed. This ensures that potential unknown creditors have a chance to see it. Step 4. Mailing to known creditors. For creditors you know about, or should reasonably discover, you must mail them a copy of the notice directly. This could include banks, hospitals, utility companies, or anyone listed in the deceased's financial records. Step 5. Filing proof with the court. You'll need to file proof with the probate court showing that you published the notice and mailed copies to known creditors. This creates an official record that the requirements were met. Step 6. Waiting period. Once the notice is published, you must wait for the creditor claim period to expire. During this time, creditors may submit claims to the court. When a creditor receives notice or sees it in the newspaper, they can file a claim with the probate court. Their claim must include details about what is owed, supporting documents, and the amount requested. As personal representative, you then have the duty to review each claim, decide whether to pay, settle, or dispute it. File objections with the court if you believe a claim is invalid. For example, if a credit card company claims $5,000, you might verify it with account statements and then approve payment. If a claim seems inaccurate or fraudulent, you can object, and the court will decide. Common questions. Families ask, what happens if I miss the 30-day deadline to publish? If you don't publish the notice on time, creditors could argue that their claims are still valid even years later. This can delay closing the estate and create liability for the personal representative. Do all debts have to be paid? Not necessarily. Florida law sets priorities. Certain expenses like funeral costs and administrative fees come first. Some low-priority debts may not be paid if the estate doesn't have enough funds. What if the estate has no assets? Even if the estate is insolvent, the notice to creditors still has to be filed. Creditors can then submit claims, but they may end up receiving nothing. Can beneficiaries be forced to return assets if a creditor files late? If the notice and deadlines were handled correctly, late claims are barred. That means heirs generally don't have to give back assets they have already received. Practical tips for executors and heirs. Stay organized. As soon as you're appointed, gather financial records, bills, and account statements to identify creditors. Publish quickly. Don't wait until the end of the 30-day window. The sooner you publish, the sooner the creditor period starts running. Mail carefully. Keep records of when and how you mailed notices to known creditors. Certified mail provides proof. Consult professionals. An experienced probate attorney can help draft and file the notice correctly and handle creditor disputes. Communicate with beneficiaries. Let them know that assets can't be distributed until creditor claims are resolved. This helps manage expectations and avoid family conflict. Here is a quick example of a real-life inspired situation. Consider the case of David, appointed as personal representative for his mother's estate in Jacksonville. He thought the process would be simple, just divide her bank accounts among the kids. But she had outstanding hospital bills and credit card debt. David published the notice to creditors within 2 weeks of his appointment and mailed copies to the hospital and the bank. The hospital filed a claim, which was valid and paid from the estate. The credit card company never responded, and after 3 months, their claim period expired. Because David followed the process correctly, the estate was able to close smoothly, and the remaining assets were distributed to the heirs. If he had skipped the notice, the credit card company could have come back years later, causing headaches for the family. Now you know exactly what a notice to creditors is, why it's required in Florida probate, the strict deadlines you must follow, and the step-by-step process to file it correctly. This single step can make the difference between a smooth probate and one filled with delays and disputes. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read every one. Here's a question for you. What part of the creditor process do you find most confusing? Identifying creditors, handling deadlines, or disputing claims? Share your thoughts below, and we may cover your question in a future video.
If this helped bring clarity to your situation, hit that like button and subscribe for more guidance.